from St. Louis Public Radio. This is St. Louis on the Air.
He decided he wasn't going to investigate it because this Chad Perkins at the time was running for office, and it sounds like there's a whole big boondoggle going on here. Not a good thing.
This judgment will send a chilling effect to all of us and make all of us think twice before we fire off a Facebook post or post something on Instagram or Twitter.
And whistleblowers, there's a limited protection there. Mm-hmm. So sometimes people think they have more rights than they really do.
I'm Sarah Fensky. 3 years ago, a woman who worked at the Steak and Shake in Florissant thought she saw worms in a hamburger patty. The woman, Melissa White, was cooking the patty for her own meal. She later testified that she perceived something to be moving in the patty. White immediately showed the patty to her managers and urged them to call the health department. But they asked her to wait, and when her district manager finally arrived, she refused to turn over the patty. She said she was taking it to the health department. The woman left the restaurant in tears with the patty. She told customers on the way out that she had been fired for reporting worms in the meat. Now, Steak and Shake said she quit rather than turn over the patty, and they note that they did get the health department on site that day. They got a clean bill of health. But Melissa White took to Facebook. She posted in all caps, quote, "Just got fired from Steak and Shake in Florissant because I found live worms while cooking a steak patty moving inside of it and refused to sell that meat. Well, right now they are still selling same meat. Hashtag no one even checked it." The post went viral. Steak and Shake sued her for defamation. And earlier this month, they won. Melissa White now owes her former employer $80,000. That's money she says could bankrupt her. Was she a whistleblower, or was she someone who recklessly defamed her employer? Well, joining us to answer that question is our Legal Roundtable. And today that includes Mark Smith. He's an Associate Vice Chancellor and Dean for Career Services at Washington University, as well as an attorney. Mark, welcome.
Thanks. Good to be back.
And we're also joined today by Nicole Gorofsky. She's a former prosecutor. She's now in private practice at Gorofsky Law. Nicole, welcome back.
Thanks for having me.
And last but not least, making her Legal Roundtable debut today is Connie McFarland Butler. She's an experienced lawyer. In 2005, she was the first African-American woman to make partner at Armstrong Teasdale. In 2009, she left that firm to start her own full-service firm in Florissant. The law office of Connie McFarland Butler handles everything from family law to personal injury to small business representation. And its founder joins us today. So Connie McFarland Butler, welcome.
Thank you so much for having me this afternoon.
So Connie, your first Legal Roundtable case is a bit of a doozy. Let's start with something simple. This Facebook post. Was this a big mistake?
I think that it was a big mistake on behalf of the employee. I think that this judgment will send a chilling effect to all of us and make all of us think twice before we fire off a Facebook post or post something on Instagram or Twitter. But I think that the employee, particularly since there was an hour between the time she left the restaurant and the time that she made this post on Facebook, that there were things that she wrote in this post that were reckless. And if you review the legal file, it appears to contradict the facts in the case.
Nicole, do you have those same concerns?
Well, I'm concerned for the employee in this case. I'm not going to say I know all the facts. I would have loved to have been in the courtroom when the jury was hearing the case. But I do think that $80,000 against an employee who posted something on Facebook just as a general practice is pretty steep. It was $70,000 in compensatory damages and $10,000 in punitive damages.
The jury was angry. They wouldn't have added that $10,000 unless they thought this was beyond the pale.
Yeah, it appears so.
Absolutely.
Mark, she tries to claim in her response to their lawsuit that she was a whistleblower. What would she have had to do to make that case?
Yeah. I think under Missouri law, she would have to show that she was going outside. And here, she reported it to the internal Steak and Shake employees, which is what was required, and she did do that. And, you know, I think the lesson here is this defamation lawsuit. First of all, as was mentioned, punitive damage, that's where the The damages don't relate to the harm suffered. They're meant to punish the person. You can't get those all the time, but for an intentional tort like defamation, you can. So when people start defaming people on Facebook, that's publishing. If you say untrue things, if you say true things, that's a defense. But you can get these damages, but then you could get punitive damages. Actually, the punitive damages, compared to the compensatory, were smaller. I was kind of surprised by that. So I think the jury probably was angry with her, but maybe not as angry as they could have been.
Well, and I'm completely guessing here, but because, again, I wasn't in the courtroom for the facts before the jury, but I think the punitive damages may have come in part from the fact that the company told her that she was mistaken and to take it down, and they actually even posted the health department report, and she did not take it down.
So she had a couple chances here where maybe she could have gotten herself out of some of the trouble she was in. Connie, I got to say, though, I was very interested. Steak and Shake filed this lawsuit within just 2 weeks of this whole incident. That struck me as extraordinarily fast.
I believe that is very fast for preparing a suit and actually getting it on file. But I think if you look at the amount of times that the post was liked and the number of times that it was shared, I believe it was shared about 36,000 times. I think that the company had to get on top of it before the horse completely left the gate.
36,000 shares is a lot.
Well, and they were trying to get injunctive relief to force her to take that post down. So, one wonders, you feel sorry for this person. She's a waitress at a Steak and Shake. She's not making a lot of money. I'm sure $80,000 verdict is huge for anyone.
Huge.
One would hope that Steak and Shake would say, as long as you, agree to take it down, agree not to do this again, we'll forgive the $80,000. One would think that a business like that would just really be interested in preserving the integrity of their products and their reputation and not in punishing some poor woman.
It is interesting.
I was going to say that would be out of the kindness of their hearts, though. They have no obligation to do so, and there's no indication so far that they're doing that.
Nicole, I wanted to ask you something as a former prosecutor. There's a really interesting part of this case, and that involves this patty. We know that when she left the restaurant, she took the patty with her. My understanding is she did not go to the health department right away with this patty. She had an expert witness who examined the patty nearly a year later, and this expert witness found that it contained 3 maggots. Now, she says it was in her freezer the whole time, but I think the big question comes down to how can she even begin to prove that? How does this work with chain of evidence here?
So I think the jury must have decided that she couldn't prove that. I think that must have been how it came down. But I also think, her argument, so I was able to read a little bit of her argument, which was she said that the manager came in and she repeatedly tried to show him the patty, and he said, I don't want to see it right now. I don't want to see it right now. So that's why she took it and left the restaurant with it. So there is a little bit of back and forth with that. But again, the jury made the factual determinations and found, that she was mistaken. There were not worms in the patty.
I don't necessarily see this as a complete vindication that for Steak and Shake that the patty did not contain worms. It was kind of a weird defense that Steak and Shake came back and said that this was actually fat that had accumulated on the outside of the bun. And the burger patty. And in my 51 evolutions around the sun, I've cooked many a burger patty, and I've never seen a piece of fat that looked like a worm or that wiggled when I cooked it. So it was a really interesting defense that was provided by Steak and Shake. I think that, if you've ever tried a case before, you never know what a jury is going to hinge its verdict on. You think that your key pieces of evidence are going to be A, B, and C, and then when you talk to the jury afterwards, they hinge their verdict on or hung their verdict on X, Y, and Z. And in this case, Ms. White made at least 4 factual assertions in that post that she put up on Facebook. And one was that the burger contained worms. The other was that she was fired for refusing to sell the meat. Mm-hmm. And there's no indication that that burger was ever cooked for public consumption or that any of the managers attempted to force her to sell it. And then she also says that right now, they're still selling the same meat. And there was no indication that she took the burger, so they weren't selling that burger. And according to the file, the burgers that they'd had remained meaning at the time that she left, they were disposed of. And then she said, no one's even checked. And that was untrue because her district manager came in, the store manager came in, and then you also had the health department officials who came in. So the jury could have said that maybe there were maggots in the meat. However, we have these 3 other points where that she published things that would have been perceived as falsehoods.
So I'm going to stick up for her again because, I'm all for the working person. So I thought what she said was that she was supposed to sell the rest of the package of meat, and she thought that this same issue was in the rest of the package. She was making that particular hamburger for herself. I've never talked about a hamburger so much on the radio in my life. But there was the rest of the package, and she felt that the rest of the package was contaminated. Now, I thought it was somewhat suspicious that apparently the Steak and Shake manager got rid of that package before the health department came in. So there are a lot of factual issues back and forth, and in defamation, they have to prove. She has a defense, that of it being true. Now, because of all of the evidence back and forth and things being removed, I think that would have been a tough sell for her. It's a fascinating case.
Mark, I find myself wondering about, as a journalist, when we are being accused of libeling somebody, there's a big issue of whether this is a private citizen or whether this is a public figure. How does this work for a corporation?
So defamation for public figures, you have to show, malice aforethought or something. You have to show that you knew it was untrue.
It's a much higher standard.
Yeah, so it's harder to meet. And here, I can't remember in this case if that even was an issue. I don't think it was.
I didn't see it in the filings I looked at because this to me feels pretty reckless. For all the reasons that Connie pointed out, she was not hewing closely to the facts, but nobody has testified that she hated her employer. People say she was actually a pretty good server.
But I think the issue is probably, I think she leaves her employer and she writes this thing in anger, which you don't want to do, whether it's an email to your friends or whatever. That's just a bad idea. But then I think she refused to take it down and I think that was probably her biggest mistake, where we told her it was not true. We presented evidence for the health inspector, and we said, take this down. It's not true. And she said, no, I refuse. I'm going to keep it up there. And so, like I said, I still feel sympathy for this person. But I think the takeaway for all of us is, we have this mechanism now where we can publish things with no checks. And I think lay people sometimes think, well, I know what I know, and I'm going to write it. It's true. Maybe it is, maybe it's not. And I'm a whistleblower, and whistleblowers are protected. And whistleblowers, there's a limited protection there. Mm-hmm. So sometimes people think they have more rights than they really do.
We're talking today to our Legal Roundtable. That's Mark Smith of Washington University. We're also joined by Connie McFarland Butler, who runs Connie McFarland Butler, LLC in Florissant. And we're also joined by Nicole Gorofsky of Gorofsky Law. If you have a question or a comment about this case that we're talking about or any of the cases that we're talking about today, you can join the conversation. Give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air, or you can email us at talk@stlpr.org. We need to take a quick break, and when we come back, we'll discuss lawsuits over a federal program aimed at helping socially disadvantaged farmers. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. We'll return to our Legal Roundtable in just a moment. First, here's a local news update. Later today, the Missouri House is expected to pass an extension of the tax on healthcare providers that funds Medicaid. The Senate passed the measure last week. The House will also consider a controversial bill that would bar Planned Parenthood from receiving any public funds. State funds are already barred from paying for abortion. Even if the bill passes that chamber, it's unclear if the Senate will take it up. And a new collegiate football league launches next year. It will include Quincy University and Fontbonne University. The Midwest Sprint Football League has one significant difference from other college football leagues. A player's maximum weight is 178 pounds. Join St. Louis Public Radio this afternoon for local and regional news, and throughout the day on our website. That's STLPR.org. And now back to our conversation. Today we've convened our legal roundtable, and today that includes Nicole Gorofsky, a former prosecutor now in private practice at Gorofsky Law, and also Connie McFarland Butler of Connie McFarland Butler, LLC, and Mark Smith. He's an associate vice chancellor and dean for career services at Washington University. I want to talk about a new case here. Earlier this year, the New York Times wrote a front page story about a farmer here in Missouri, in LaGrange. Shade Lewis is 29. He's black, and he'd recently been awarded $200,000 from a federal program designed to help farmers like him. Now, the New York Times reported that African Americans represent just 1.4% of farms across the U.S. That's after owning 14% of farms in the 1920s. And the Biden administration designed its new debt relief program to assist those farmers of color. But that program has triggered lawsuits. That includes one in the Southern District of Illinois. The suit seeks to, quote, challenge a law that distributes benefits and burdens on the basis of race in violation of the Fifth Amendment to the Constitution. Similar concerns were raised in Florida. A federal judge there put a temporary halt to the program there last week. So there's some big legal issues here. Nicole, I'm curious for your thoughts on this. What would it take for plaintiffs to succeed in the long run on this case?
So basically, this is an Equal Protection Clause issue. And so what we're talking about under the Equal Protection Clause is that it has to be race neutral. And so you can't treat one race differently than the other. The Supreme Court has been pretty clear on that. And so basically what the plaintiffs in this case are saying is it's making determinations based on race. So in other words, they're saying it prejudices white people and preferences black people in farming. And essentially, this is affirmative action in farming. And so in order to win here, I think they have to be able to prove that this is affirmative action in farming and that's prohibited.
Let me stop you here. As a non-lawyer, isn't affirmative action legal?
You know, the United States Supreme Court has found that in situations like this, no, affirmative action violates the Equal Protection Clause.
So how come universities can do this and the USDA can't do this?
Well, I think there are a couple issues here. One is they've got this disadvantaged group, and they've defined it by people of certain races. And I think it's important to remember that Congress is doing this because with the previous COVID relief, they found that the relief was going disproportionately to white farmers. And so minority farmers, which make up a smaller section, were not getting the relief. So they were trying to remedy that. Mm-hmm. With the affirmative action with higher ed, this has been under attack. There's been the Harvard case that's been going on the last couple of years. There was the Fisher case out of Texas, which came up. There was the Michigan case. So, and the Supreme Court has said, I think, what was it, like 10, 15 years ago when Justice O'Connor, wasn't it, who said, affirmative action, we're not going to be able to do this. It's going to end at some time and put out 25 years. And I think that was like 10 years ago. Mm-hmm. So, particularly with this Supreme Court we have now, very conservative, I think there's a good chance, if it's the Harvard case that gets to the Supreme Court, Texas has got another one, something's going to bubble up to the Supreme Court, and they're going to probably say you cannot consider race, period. Mm-hmm. And that's what's kind of happening in this one. We've got an injunction. We'll see what happens. They've got the government's got to make the case, like I said, which is we're trying to remedy this mistake we made before. The court's going to say there are better ways to do it.
Even beyond the mistake they made before, I mean, there's historic evidence of discrimination. I mean, doesn't that give an opening for the Biden administration to come up with a narrowly tailored program to address that?
I would argue yes, that it does, but I do tend to agree with Mark. I think the thought process is that affirmative action has been in place for a number of years, and that I guess the goal is to even the playing field. And there are those, from their perspective, who believe that the playing field has been equalized, which I would argue that it has not. But I believe that given the makeup of the court and with the Trump administration packing the federal courts with conservative judges, I think that it's just a matter of time before affirmative action comes to an end in the U.S.
Well, and to be clear, this may not be an incredibly difficult fix, even if it's struck down. So it can't be purely race-based. So there may be other things that the Biden administration can add to this law to make it not purely race-based. So first of all, the plaintiffs would have to actually win on that ground, that it is purely race-based. But then I think the Biden administration could come in and actually put in some other elements there that make it less purely race-based and actually get it by.
So if you say we're going to try to help all disadvantaged farmers and we're maybe going to give a preference to those who faced historic discrimination, but also open this same program to white farmers?
Or maybe people who weren't able to take advantage of the previous COVID relief that was put out there. I think that could be. But, with the justification for affirmative action, it used to be kind of rectifying this long period of wrong. And now, particularly with higher ed, the court has said, no, we're justifying it because it provides an advantage to all the students, particularly, and I might be getting this wrong, but I don't think I am, the white students, that they benefit from this diversity, and the college recognizes it, so they're going to, the court is really kind of, with Brown versus Board of Education, it was about we're stigmatizing the African-American students, and now it's like, we're trying to help this.
We're saying diversity is a good goal.
But
you might have a harder time with a program like this.
But this idea that everything's great in the world now, it's all over. But when you look at all the numbers, it's not. It's not equal. It's not. The outcomes are not the same. So, but the courts are going to kind of say, yeah, well, too bad.
So this Florida ruling that has put this program on hold, would that be enough to halt this across the U.S., or is that only going to matter in Florida's jurisdiction?
It is enough to halt it across the U.S.
So at this point, this money is not flowing out to
these farmers. It's a preliminary
farmers.
injunction. So they're going to then, the Justice Department or Department of Agriculture, whoever's taking it, will try and justify it, and we'll see what happens. But I'm like Connie, I'm not overly optimistic. I would like to be.
I want to talk about another lawsuit involving government. This time it's state, not federal. Missouri Governor Mike Parson signed into law last month the Second Amendment Preservation Act. This new law imposes a $50,000 fine on any state or local official who enforces a federal gun law that's not also a Missouri law. The rule also says that federal laws that infringe on the Second Amendment are invalid in this state. Now, there have been a lot of people who are not lawyers who have just flat out said they can't do that. And I come back to the question of, can they not do that? They appear to have done it. There's now a lawsuit from St. Louis City and County challenging this program. Connie, do you think that they have what it takes to stop this law?
I think that they do have what it takes to stop this law. I think that this law is problematic for a number of reasons because it basically violates the supremacy clause of the U.S. Constitution. The U.S. Constitution and the federal law is the law of the land. And if state law contradicts federal law preempts or trumps state law. So this bill on its face violates the supremacy clause. So I think that the governor is going to have a very difficult time keeping this law in effect. I think that it will be deemed as or determined to be unconstitutional. And then there's a lot of, he's gotten a lot of blowback from the law enforcement community. So law enforcement is not on board with this legislation that just passed. All of the chief of police and sheriffs of many of the major cities in Missouri have come out in opposition to this law. So
this law, I'm sorry, go ahead.
Go ahead.
Well, this law is becoming, I think, is, representative of a terrifying issue that's happening in Missouri a lot, which is, legislation or lawsuits where any legal person, any attorney, any person with any legal knowledge whatsoever would know that these things can't get by, and or some of Eric Schmidt's lawsuits where we know that, they can't, there's no standing, the case can't make it through the courts, but this is completely political posturing. And it's wasting taxpayer money, and you know that there's going to be litigation over this Second Amendment Preservation Act, and it's just, I can't understand why it keeps happening. It's just a waste of, it's political posturing to waste taxpayers' money, and it's ridiculous. Anyone who's a lawyer knows this is a violation of the Supremacy Clause.
Isn't it crazy to think, as a city resident or a county resident, we're paying for the lawyers on both sides of this case? Like, that seems insane. But, Mark, I have seen people raise the argument. They say, how is this different from cities declaring that they're a sanctuary city? I think this was more of like a Trump administration thing. They were not going to enforce federal immigration law.
Yeah, they were saying, we're not going to use our resources at your discretion. So there they were saying, we're not going to let the feds come in and use our local law enforcement to do federal policy. You can do it yourself, but we're not going to send our resources. On this case, and I'm tapping into my inner conservative today, which I don't have a whole lot of it. But I feel kind of sorry for Governor Parsons because, he's a sheriff. He likes law enforcement. And I'm sure, this bill comes out and politically, he probably knows this is going nowhere. But politically, people are saying Second Amendment. You still have Second Amendment protection. I've talked to people about this, and they've said, well, why can't they do this? Because I have a Second Amendment right. You do. And you could, if some state passes some law that violates your Second Amendment, you can go to the courts.
You've got a great lawsuit there, yeah.
That's what happened in Chicago. That's what happened in D.C. with the lawsuits that kind of expanded the Second Amendment rights. So I don't think we need this. I understand the political, how it's viewed, and you're in a difficult position. But
you can't be the governor who vetoes the Second Amendment Preservation Act.
And listen to Mark having empathy for the governor today.
I know. I'm come out for big business, and the Republican governor. I'm like, I don't know.
Well, let's see if you can defend the lawmaker on this one. This is a criminal case involving a lawmaker in Pike County. Chad Perkins is a Republican from Bowling Green serving in the State House. He's accused of having sex with a drunken 19-year-old while he was on duty in 2015. He was her DARE officer. How much do you love that detail? She told the AP that, she was drunk and she remembered only bits and pieces of the encounter, which involved sex in the back seat of his police car. Now, he says, we did not have sex while I was on duty, but even if I did, that wouldn't have been a crime committed. So why would I lie about that? Nicole, I know that sex crimes are something that are very close to your heart. This is something that your firm specializes in. Could he be in legal jeopardy here for having sex? 19 is of age.
He should be. It sounds like she was completely incapacitated. She says she was incapacitated, which means she was not able to consent. And it also sounds like this law enforcement officer who was asked to look into this completely swept it under the rug. He decided he wasn't going to investigate it because this Chad Perkins at the time was running for office. And it sounds like there's a whole big boondoggle going on here. Not a good thing.
So the officer who was supposed to investigate it and didn't for political reasons, is this something where he could be in legal trouble?
Sure, I think he should be investigated for dereliction of duty, and I think this is a big problem.
And so the idea of being too drunk to consent, that immediately, this becomes illegal for somebody to have sex with you at that point.
Yeah, if the sex is non-consensual, that's rape.
So, Mark, I know you have been defending some people today. You defended the governor. Do you want to defend this Pike County lawmaker?
Yeah, nice try. No, I'm not going for that either. I think it's going to be, at higher ed, we have Title IX, so how we define consent is different than how the law defines consent for a criminal charge. And I think it's going to be tougher to prove rape in this case and satisfy legal, and whether or not a prosecutor would decide to take that forward. But it sounds like this guy was doing it on the job under the color of law. I think this is a big mess, and I'm really shocked that he's still in the legislature, that they haven't sanctioned him somehow.
This story came out about 3 weeks ago.
It's been a while.
The woman confirmed it. He's still there. Connie, any thoughts on this one?
Well, he is presumed to be innocent. until he is proven guilty. So the facts are messy. It stinks. But he does have the protection of the law.
We're talking today to our Legal Roundtable. Making her Legal Roundtable debut today is Connie McFarland Butler of the law firm of the same name in Florissant. We're also joined by Mark Smith of Washington University and Nicole Gorofsky of Gorofsky Law, LLC. We need to take a quick break. Coming up next, we'll discuss the Missouri Sunshine Law. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. Our Legal Roundtable is in session today, and today it includes Nicole Gorofsky, a former prosecutor now in private practice at Gorofsky Law, and Connie McFarland Butler of Connie McFarland Butler, LLC, and Mark Smith, an associate vice chancellor and dean for career services at Washington University. Now we have what we call breaking news here in the radio business. This is a ruling that came down yesterday from the Missouri Supreme Court. This case was filed by Elad Gross. He's a former Democratic candidate for Attorney General. He had sought public records on former Governor Eric Greitens. Well, he was given a bill for $3,618, and that included some charges for $40 an hour for research for staff to prepare these records. They also said it would take up to 120 days. Elad sued the governor, alleging that the governor's office, even though now it's Mike Parson in this office, not trying to cover up records of his own administration, but of a past administration, saying that this was a violation of the Missouri Sunshine Law. The court agreed. This was a unanimous verdict, 6-0 on this one. Nicole, what did they find here?
Well, they found essentially that Parson has to follow the statute, which is should not be difficult. But basically, they can't charge for attorney review, which they were charging a significant amount of money for attorneys in the governor's office to review the documents before turning them over. There's no mechanism in the statute to charge for that. They found that when they redact parts of records that they have to explain why they're making those redactions. They found that if there are going to be time delays, you have to explain those time delays. All of these things are in the statute and should have been followed. So sometimes I'm on here talking about things that only lawyers love. This is something I love because there are violations of this Sunshine Law happening left and right, and we just often feel like, oh, well, there's nothing we can do about it. But this is a win.
I got to say, this is one where if you had told me that total, I would have said, yeah, $3,600. They can manage to get it up to that 120 days. They do that all the time. Obviously, there's a lawyer who decided to fight this thing. Connie, do you think this puts government agencies on notice?
Absolutely. I think it does put government agencies on notice that, if you receive these requests, that you certainly have to comply with the letter of the law, or you may end up before the Missouri Supreme Court. And I think that it was very determinative that you had a 6-0 decision, that you got all the stars to align, and all of the Supreme Court justices agreed that this was, in fact, a violation and sent it back down for remand.
Mark, it feels like there's been a number of these kind of Sunshine Law verdicts lately. It seems like there's almost like a groundswell going on where the court is saying, you can't do this, you can't do this. And yet we still seem to keep seeing these cases.
I think part of it is you have people like Elad who are bringing these cases and are kind of acting as representatives of the public, doing a good job. I think you get turnover and everyone kind of looks at it for the first time and has this sense, well, that's private. I should be able to keep that private. And one of the things I found interesting, besides what was already said, which is you cannot charge for attorney review time, that you're supposed to do that just on your own. But the other thing was the presumption is that the records are public. Not the presumption is the records are private and you have to prove that. And just seeing that reminder. Now, having said that, once again, I'm going to, when I was on the police board, we got sued for sunshine requests and I think we lost. And sometimes it's just like, well, this seems like it and the lawyers are telling you that. And so, but I don't think it's right. And we should have looked at it harder and said, no, let's resume. But
to push back on the lawyers a bit.
Push back on your staff and the people who are saying, no, we need to fight this because what about the future? And I just think we've got these sunshine laws because we want it open. We want the sunshine to come in, and people just have to get on board with that.
Boy, I hope that people are listening and that they do. Speaking of the Missouri Supreme Court, the fight over Medicaid expansion appears to be headed there. That's after the advocates for expansion lost in state court. Cole County Judge John Beadham said the ballot initiative that approved Medicaid expansion was unconstitutional. It was very interesting for me to read. This is an issue that the state attorney general did not even raise in this case. It's something that the judge just kind of landed on. Connie, are you surprised that he would go around the pleadings and end up bringing it back to this bigger picture that wasn't even being argued?
I am a bit surprised. Typically, the rule is that you have to ask for it, you have to pray for it in order to receive it. In this case, there was no request, there was no prayer, but the judge answered the state's, I guess not a request, but gave them essentially what they wanted. I don't necessarily think that the judge, Judge Beadham in Cole County, necessarily got it wrong in his analysis. I think that initially this was reviewed by the court in the Cladd case previously, and they kind of punted the ball. Oftentimes judges will do that and say that, hey, this isn't right. This isn't something that we should address at this time. And so they just kind of kick the can down the road. And I think this judge picked up the can and ran with it.
So that seems kind of disturbing to me. It seems like somebody could put on a whole campaign to convince voters to approve something. Voters go ahead and approve it. And as Connie mentioned, there was litigation saying this shouldn't even be on the ballot. And now after the fact, the judge can say this shouldn't have even been on the ballot? Doesn't that seem a little out of time?
Yeah, well, I don't know. When you read this article, what is it? Article 3, Section 51, 51. It says the initiative shall not be used for the appropriation of money. And so they're saying that's what this is. Here's what this reminds me of. And you guys are too young to remember the Hancock Amendment when it was passed in like the early 80s. And it said that the state couldn't put in place requirements that localities then had to basically spend more money on than they did. And it really shifted the relationship. This case seems like if this is upheld by the Supreme Court, it seems like I can imagine most initiatives require some money. So it seems like it would really dramatically undermine the initiative process for change. And this was a change to the state constitution, too.
That's right. It was a constitutional amendment. And Judge Beadham is saying that there's always been this law in place that you can't do an initiative that would require the state to spend money without a funding mechanism. I don't know if that just hasn't been enforced over the years.
I guess not.
But it boggles my mind a little bit because there's already funding for Medicaid. Yeah. And then the argument is there's not going to even be additional funding from the state because the federal government is giving the money. And so it is a little bit mind-boggling that this is coming up now after, like you said, all of the campaigning has gone on and the Missouri Supreme Court already addressed it and allowed that to happen.
So we had Chuck Hatfield on the show about a week ago. He is the attorney who brought this case trying to force Medicaid expansion. And he noted that they feel like they have a good argument that this expansion would pay for itself, that there's going to be some costs for Missouri on the front end, but that this then unleashes federal funding. However, he noted they didn't really get to develop that part of their case because, again, this was not at issue in what was being looked at in the litigation. And so is this a problem for them then when they have to go in front of the Missouri Supreme Court?
Well, this is exactly why courts aren't supposed to bring up their own issues. It's called sua sponte, when a court brings up an issue that the parties didn't bring up, because it does put parties in a bad position because they didn't get to fully address the issue the court might be wondering about. And so you're supposed to leave it to the parties to bring up the issues to be addressed, and that is a problem.
So did Judge Beadham err by coming in with this and bringing up this argument that he himself acknowledges they did not raise?
Well, so there is a higher standard in the Court of Appeals for addressing issues that come up sua sponte. So we'll have to see what the Court of Appeals says. It is going to be a higher level of scrutiny.
So another thing Chuck Hatfield said when he was on the show, he said they're going to take this straight to the Missouri Supreme Court because he said this is a constitutional issue. This is where it makes sense. Would that still apply, Nicole, in the Missouri Supreme Court?
Well, so it's going. So it's very complicated, but because Judge Beadham decided on the issue that he decided on. That's why it does get to go straight to the Missouri Supreme Court, because he decided it on a constitutional issue. So the Missouri Supreme Court gets to take straight jurisdiction on Missouri constitutional issues. But yes, I think that it does, the appellate procedural issues on a judge raising something sua sponte still applies.
It's interesting. The judge wrote in this case, he said, if Amendment 2 was validly enacted, the plaintiffs, the people trying to force Medicaid expansion, are absolutely right. That's a quote. They are absolutely right. Connie, does that bode well for them at the Supreme Court, that he's saying, if this is the question, they're right? He's just saying he thinks it's a different question.
Well, I think that there are some positive aspects of the ruling that was rendered by the court, and that is the first line in the analysis section. If the second, if the Amendment 2 was validly enacted, plaintiffs are absolutely right. And then the court goes on to acknowledge that the state in its arguments were arguing semantics and that they were performing legal gymnastics with the arguments that were being offered to the court. So I don't think that this is necessarily a slam dunk for the state. I think that the court recognizes that there are issues on both sides of this equation.
So this brings up our Attorney General, Eric Schmidt. It was his lawyers who fought this thing, and they did get the victory, again, without raising the thing the judge said they should have raised. He also lost a case at the U.S. Supreme Court in the last month. This was a case involving Obamacare. Previously, this same group that he worked with on this challenged the election results in Pennsylvania. They also took a pretty decisive loss there. Mark, what do you make of all this?
Yeah, this is what we've kind of were talking about before. I think these lawsuits are more political lawsuits, and like you said, we're paying for the lawyers on both sides. We're paying for our state AG, and then we're paying for oftentimes federal folks who are defending it, and it just doesn't seem like a good use of resources. And this Obamacare one, you know, they were kicked out on standing, and somebody wrote a op-ed on it. I think it was Ray Hartman. It basically said, look, you can't even get to the issues, substantive issues. You should see that. And the substantive issues have been to the Supreme Court a bunch of times, and they've lost. So I just think it's probably political grandstanding, probably not the best use. I mean, it's like he also sued China. He's had some pretty interesting cases, which I'm not sure should be the highest priority.
Yeah, it's interesting. It does seem like there's a lot of resources going into this. And I understand this is the trend for attorneys general, that they're out there fighting the federal government and sometimes fighting each other. But it seems like that, you know, the attorneys on that staff are not that highly paid. What we pay assistant attorney generals in this state, frankly, is a scandal, I think. And they have to take on a bunch of really complicated cases close to home. Shouldn't that be enough to keep them busy?
Well, absolutely. And I think it was some interesting verbal judo by Eric Schmidt in the press, too, by saying, oh, it's such a shame that the court didn't even address the merits and kick this out on a technical issue, when it was actually the lack of standing, which he should have known when he brought the case, that he couldn't even show the basic threshold level that this would affect, past or future injury in Missouri, which is the basic threshold level to get to the merits. So it was something he already knew, and then he blames the court for that. So, yeah, I mean, this is political posturing.
So I want to talk about a case that hasn't triggered much politicking at this point, but this is an interesting case that could be a criminal case. There's a restaurant in the city in the Benton Park neighborhood called Utah Station. It's a vegan restaurant. A young man allegedly stole the restaurant's tip jar, and a customer confronted him as he was apparently leaving the restaurant with this tip jar. And the young man, the alleged thief, started beating the customer who'd confronted him. The owner of the restaurant came out. He allegedly opened fire, and he shot this alleged thief. And now authorities arrested the owner of this restaurant. They said they planned to seek warrants from the circuit attorney's office to charge him with assault. Now, I checked in this morning with the St. Louis Circuit Attorney's Office. I didn't see anything in CaseNet on this case. They said it's still being investigated by police. It appears at this point that the restaurant is closed. I'm fascinated by this case because this alleged thief was behaving aggressively towards a customer. Did the owner of the restaurant have the right to intervene and intervene with his gun? Connie, any thoughts on this one?
Yes, ma'am. You have the right to act in self-defense of others. So clearly this young man had assaulted this customer and there was some type of physical exchange that went back and forth between the parties. So the restaurant owner did have the right to defend this patron of the restaurant. However, the force that is exerted by the restaurant owner must match the force that's being exerted by the young man who stole the tip jar. So there's a question as to whether or not the force that was used by the restaurant owner equaled that was being exerted by the young man who stole the tip jar. So I think that the restaurant owner will definitely get a lot of sympathy from the public for his actions, but I think that the prosecutor's office will have to closely evaluate this to determine if appropriate force was used.
So, Nicole, that question of appropriate force, let's say that the alleged thief was beating the customer with a brick as opposed to just his hands. At that point, is a gun considered fair play?
Sure, I think that would be a much stronger argument, and it's not apparent from some of the descriptions that I've read what exactly he was doing. I've heard it called a shove. I've heard it called an assault, but I'm not exactly sure what was going on there between the customer and the boy, and that's going to become critical for the analysis. So, it has to be a reasonable belief that this level of force was necessary.
And I was just going to say, what was it, about 10 years ago, the legislature passed this enhanced castle doctrine law to protect, and it provided, but that extends to protecting your home. They also extended it to your car. They offer pretty broad protections for people who shoot somebody while they're doing that, but I don't think it extends to this particular situation.
Right, because I think in this one, they were already outside. They had already left the restaurant and were outside and,
And I'm not sure a restaurant would be considered, I haven't looked at the language, but that's different than a home, I would think. So
I wonder if it's still different for a home if you own the restaurant versus if he was just an agent
and then
of
you
it.
Get to,
he was the owner.
Yeah, cool issues like, well, what if he lives on the second floor? That's not like a
you
law school
lawyers,
exam.
you
I
always
did think
love
this
the
would be
possibilities.
a great law school exam.
Here's the thing I find myself wondering. Does it matter if the alleged thief beat the customer or if he was currently still beating him in terms of the analysis of whether this is justifiable force?
Yeah, if he was done and leaving, then it's clearly illegal.
Okay.
Yeah, but
even if he beat him with the brick, which again is a hypothetical that I just made up for the purpose of this law school seminar.
Right. If it's over, it has to be imminent danger. It can't be over.
So there's a lot of questions the St. Louis Circuit Attorney's Office is going to have to dig into in this case.
Then the other thing, we haven't talked about the civil issues. So, the thief might bring some kind of intentional tort action, like we were talking about at the beginning, for battery. You can't go out and shoot somebody. Yeah, the thieves could sue the owner of this restaurant saying, you shot me. He's going to argue what was said before about the self-defense, the defense of others. Like Connie's raised, that's a pretty good defense, but if the assault is over, it's not defense of others. It's just revenge, and that's not protected.
Well,
I doubt he's going to find a very sympathetic jury, though.
Yeah, right.
Thinking the same thing.
That's going to be a hard road there.
It's a hard sell.
Yeah.
So we have just about a minute and a half left here. I would be remiss if we did not close the book on the McCloskey case. Mark McCloskey gained national attention after brandishing a gun at protesters walking past his home. Now the special prosecutor offered him a plea, also offered his wife Patricia a plea. They took it. Was justice served by Mark and Patricia McCloskey being allowed to plead guilty to misdemeanors? Mark?
First of all, you've said a number of times on previous shows, this is the last time I'm bringing up the McCloskeys. So I'm not believing you on that.
This might be the last.
I think it's Callahan, right, who
the former
was a former
U.S.
U.S. attorney.
Yeah.
I think he cut a good deal. Let's get this done with and move on. This is not a good use of our resources, I think.
Nicole, was justice served by the misdemeanor?
I think we've given the McCloskeys their 15 minutes and then some. Fourth degree assault for Mark, which means he purposely placed another person in apprehension of immediate physical injury. harassment for Patricia, which means she didn't have good cause and she engaged in an act with the purpose to cause emotional distress to another. I think those fit pretty well, and I'm going to declare justice has been served.
All right, we have 2 votes for justice here. Connie, what's your thoughts on misdemeanors here?
Well, I disagree with my panelists. I don't think that justice was served in this case. I think that the prosecutor should have sent a message to other residents of the city that you can't just simply go around waving your AR-15 and your semi-automatic handgun when there's no threat directly to you. So, no, I disagree with these misdemeanor charges. Mr. McCloskey gets to continue to run for the Senate. And now the question becomes whether or not they retain their law license. That's another story. But no, I don't think justice was served.
And you know what? We may get to talk about them again if the
Connie,
bar comes after
just
this.
for the record, you do agree we shouldn't talk about it anymore.
I like it.
And that's why she's my new favorite panelist. Yeah. Connie McFarland Butler making her Legal Roundtable debut. Thank you so much for joining us today. You've done a terrific job.
Thank you.
And Nicole Gorofsky of Gorofsky Law. Thank you.
Thank you.
And Mark Smith, Associate Vice Chancellor and Dean of Career Services at Washington University. Thank you.
Thank you.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here. If you learned something new from today's episode, consider leaving us a review and rating on Apple Podcasts on the App Store. It's the easiest way to help people discover our show. We appreciate it. Thank you. St. Louis Public Radio is a member-supported service of the University of Missouri, St. Louis.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.